If you became a United States citizen through the naturalization process, there are some important policy developments you should be aware of as we approach 2026. For many years, obtaining citizenship was widely considered the concluding chapter of the immigration journey, a permanent status that provided lasting security. However, recent shifts in enforcement priorities have prompted many naturalized citizens to ask questions about the stability of their status. Across the country, changes are occurring within the immigration system. Internal procedures are being updated. Cases from previous years are reportedly being examined again. Files that remained closed for extended periods are now receiving renewed attention. Unlike previous enforcement efforts that concentrated primarily on border security and recent arrivals, this approach focuses on individuals who completed the legal naturalization process and have been living as citizens for years. This is what distinguishes the current situation. For more than 26 million naturalized citizens, the general understanding has been straightforward. Once citizenship is granted, it remains permanent. That understanding is now being examined in ways that merit attention. So what exactly is happening? Who might be affected? And how significant are these policy changes? These are the questions we will address today with clarity and accuracy so you can understand what is occurring and what it might mean going forward. Let me introduce myself. I am here to welcome you to U.S. Immigration Info, where we explain the latest immigration developments in a straightforward, factual, and accessible manner. If you have ever felt uncertain about complex legal terminology or wondered how new policies might affect you or your loved ones, you are in the right place. If you find this video helpful, please hit the subscribe button, turn on notifications, and give it a like so you never miss important updates delivered straight to your smartphone. In this video, we will examine a significant policy development that is generating discussion across immigrant communities, particularly among naturalized citizens who believed their immigration process was complete. We will proceed methodically, distinguishing verified information from speculation and helping you understand what is actually happening. To fully appreciate why this topic is generating interest, we first need to examine what United States citizenship has traditionally represented and why that established understanding is now receiving new scrutiny. For decades, American citizenship was regarded as one of the most secure legal protections available. Once someone completed the extensive immigration process, passed required background checks, lived as a permanent resident, and took the oath of allegiance, that moment represented completion. It signified stability and belonging. A U.S. passport was more than a travel document. It was confirmation that the years of documentation, interviews, waiting periods, and uncertainty had concluded. Naturalized citizens structured their entire lives around this understanding. They purchased homes, established businesses, raised families, and planned their futures with confidence, believing that their status was permanent. This understanding became deeply embedded in immigrant communities, shared as reassurance across generations. The message was consistent. Once you become American, that status is secure. However, a different approach is now taking shape within government offices. What was previously treated as an extraordinary and rarely used legal procedure is being discussed as a more regular practice. This shift is what has many naturalized citizens paying close attention. The reason for this increased attention is a notable change occurring within U.S. Citizenship and Immigration Services, known as USCIS. Traditionally, immigration enforcement concentrated on individuals attempting to enter the country without authorization or those who violated visa terms. The system was primarily designed to manage borders and regulate new arrivals. Now, internal guidance circulating within immigration offices indicates that attention is shifting toward reviewing individuals who already obtained citizenship in previous years. Field offices across the country are reportedly being encouraged to actively examine old naturalization cases that could potentially qualify for denaturalization, the legal process of revoking citizenship. Rather than waiting for clear instances of serious fraud to surface, officers are being directed to review previous files and identify potential issues. Once a case is flagged, it can be referred to the Department of Justice, where government attorneys decide whether to pursue formal legal action. This represents a fundamental change in approach. Citizenship review is no longer only about clear criminal activity or national security concerns. It increasingly involves re-examining documentation, statements, and applications that were approved years ago. For naturalized citizens who believed their immigration story had concluded, this feels like significant change. What makes this development particularly notable is the scale at which it is reportedly being implemented. Internal objectives reportedly indicate that immigration offices should be identifying between 100 and 200 potential denaturalization cases monthly. This means thousands of old citizenship files could be reopened and examined each year, something that was quite rare in the past. To appreciate how significant this change is, it helps to examine historical context. For many years, denaturalization was reserved for the most serious circumstances, cases involving clear and intentional fraud, serious crimes, or national security threats. It was considered an exceptional legal tool, not a routine enforcement approach. Over approximately an 8-year period starting in 2017, the total number of denaturalization cases filed nationwide was only about 120. That averages roughly 15 cases annually in a country of more than 300 million people. Under the new approach, those numbers could potentially rise to between 1,200 and 2,400 cases annually. That represents a substantial increase compared to historical averages. Such a significant change alters the nature of the system. What was once exceptional begins to appear more routine. When enforcement objectives are connected to regular targets, the way cases are handled can shift. Instead of concentrating only on the most serious violations, there may be pressure to identify more files that might qualify. Legal experts note that in this type of environment, the criteria for what constitutes a concern can gradually expand. Minor inconsistencies, forgotten details, or small errors that would previously have been overlooked may suddenly be treated as significant issues. This possibility is generating concern among naturalized citizens because it raises an important question. If standards become stricter and reviews become more thorough, what does that mean for citizenship security? Under federal law, revoking someone's citizenship is designed to be extremely difficult. Naturalization is intended to be permanent, and the legal standard for revocation has traditionally been very high. The government cannot simply reconsider years later because of new policy preferences or changing priorities. To revoke citizenship, federal prosecutors must demonstrate that the individual obtained it through intentional fraud or by deliberately concealing important information during the application process. There must be clear evidence that someone knowingly provided false information, purposely misrepresented facts, or used illegal methods to secure their status. Honest mistakes, misunderstandings, or simple clerical errors were never intended to qualify for revocation. The law distinguishes between deception and human error. Memory lapses, translation difficulties, or minor inconsistencies in paperwork are not supposed to be treated as criminal conduct. For decades, that distinction served as important protection for millions of immigrants who navigated a complex system in good faith. However, immigration attorneys and former officials are now noting that the application of these laws may be gradually changing. When enforcement agencies operate under numerical expectations, the interpretation of what constitutes material information can potentially expand. Something previously dismissed as minor could be reclassified as significant. A difference in travel dates, an incomplete address history, or an incorrectly remembered job title from 20 years ago could potentially be presented as evidence of intent to deceive. This is where genuine concern begins. Many naturalization applications were completed decades ago, often without legal assistance, by people completing complex forms in a second or third language. Records were maintained on paper, not in digital databases. Details that seemed unimportant at the time may not perfectly align with modern government records. None of that automatically indicates fraud. But in a more intensive review environment, even innocent discrepancies could potentially become problematic. To understand why this matters so deeply, consider the situation from the perspective of an ordinary immigrant family. Imagine someone who arrived in the United States 30 years ago, worked diligently, followed every requirement, and eventually became a citizen. Over the years, that person built a career, paid taxes, raised children who were born as Americans, and fully integrated into society. Citizenship was supposed to be the final chapter of their immigration story. Now, imagine receiving a notice from the government indicating that an application filed decades earlier is being reviewed again. A forgotten short trip abroad, a slightly incorrect employment date, or a form completed with some confusion could suddenly be questioned as possible misrepresentation. For naturalized citizens who believed their status was secure, this possibility introduces uncertainty they never anticipated. The process itself can be emotionally and financially demanding, even if the person ultimately demonstrates their good faith. Legal proceedings over citizenship can extend for years, deplete savings, and create ongoing stress for entire families. Children, spouses, and communities are all affected when a family member suddenly finds their citizenship under review. What makes this situation particularly significant is that the vast majority of naturalized Americans followed every requirement the system asked of them. They waited in lines, attended interviews, submitted fingerprints, passed background checks, and trusted that once the oath was taken, the matter was settled. Now, many are learning that in certain circumstances, past applications can be examined in ways they never anticipated. Government officials who support this approach state that the objective is not to target ordinary citizens who followed the rules. Public statements emphasize that denaturalization efforts are intended to protect the integrity of the immigration system and to address past cases where serious fraud occurred. According to this perspective, the focus is on individuals who allegedly concealed criminal histories, hid serious offenses, or used false identities to obtain citizenship. From that viewpoint, revoking citizenship is presented as a necessary tool to ensure that people who should not have qualified do not continue to benefit from deception. Supporters argue that citizenship is valuable and that anyone who obtained it through dishonest means should not be permitted to retain it, regardless of how much time has passed. However, others point out that good intentions do not always translate into fair outcomes. When policies expand and quotas are introduced, the distinction between serious wrongdoing and minor error can become unclear. The concern is that a system designed to address genuine fraud might affect people who simply made ordinary human mistakes. That is the core of the current discussion. No one disputes that true fraud should have consequences. The real question is how broadly that definition will be applied and how many people could be affected in the process. What makes this moment especially significant is that denaturalization is occurring alongside a broader immigration enforcement agenda. In recent years, the United States has implemented various policies aimed at tightening control over entry. Asylum rules have been modified, refugee admissions have been adjusted, and visa programs have faced increased scrutiny. But all of those measures shared one important characteristic. They focused on people outside the United States or individuals attempting to enter. The new focus on reviewing and potentially revoking citizenship is fundamentally different. It concerns people who already completed the entire legal process and already became full members of American society. For the first time, enforcement priorities are shifting from who can become American to who may remain American. That change carries significant weight. Citizenship has always been viewed as permanent protection, a status that once granted could not be questioned. Now, even without widespread revocations actually occurring, the existence of this policy is creating discussion across communities. Naturalized citizens are beginning to wonder whether forms they completed decades ago could be examined. They are questioning whether a mistake made long ago might be reinterpreted as intentional misrepresentation. That uncertainty alone represents a significant development. When people begin to question their own legal status, even after following every rule, the relationship between immigrant communities and the government begins to shift. To understand the potential scope, it is important to consider the size of the population involved. Today, there are approximately 26 million naturalized citizens living in the United States. Every one of those individuals was born in another country, went through the legal immigration system, and was eventually granted full citizenship rights and responsibilities. That number continues to grow annually. In the most recent year, more than 800,000 immigrants took the oath and officially became Americans. Each did so believing they had achieved a permanent and protected status. But when policies expand and enforcement targets increase, even a small percentage of reviews can affect a large number of people psychologically. If thousands of old files are being examined annually, the sense of security for millions may be affected. One group watching these developments particularly closely is the Indian American community. After Mexico, India is the second largest country of origin for naturalized U.S. citizens. In the past year alone, nearly 50,000 Indian-born immigrants became American citizens, representing more than 6% of all naturalizations. Many of these individuals arrived on employment-based visas and spent years, sometimes decades, navigating a complex system before qualifying for citizenship. They waded through extended green card backlogs, renewed temporary statuses repeatedly, and built their lives step by step in the United States. For them, naturalization was not merely a legal milestone. It was the conclusion of a long period of uncertainty. Now, with discussion of denaturalization quotas and expanded reviews, many are beginning to wonder whether the conclusion they reached may not be as permanent as they believed. The impact of that realization is significant. For many Indian American families, the path to citizenship was an especially lengthy journey. Large numbers arrived on H-1B work visas, filling important roles in technology, medicine, engineering, research, and business. They spent years contributing to the economy while waiting in immigration backlogs that often extended for a decade or longer. Some lived in temporary status for 15 or even 20 years before receiving a green card. Only after additional years of permanent residency were they able to apply for citizenship. By the time they naturalized, many had already built entire lives in America. Their children grew up attending U.S. schools, and deep community connections were formed. Citizenship was supposed to be the final confirmation that all those years of patience had been worthwhile. But under an expanded denaturalization approach, that sense of completion is being replaced with new questions. Immigration attorneys report that naturalized citizens are suddenly asking things they never imagined needing to consider. What happens if a date on an old form was slightly incorrect? What if a short trip abroad was not recorded precisely? What if information on a green card application years ago does not match exactly with what appeared on a later citizenship form? These concerns are especially present for people who naturalized many years ago when records were kept on paper and memories of past details have naturally faded. For them, the concern is not about having done anything wrong. It is about the possibility that normal human imperfection could be treated as something more serious. The idea that a life built over decades could be questioned by a technical inconsistency feels unjust to many who followed every requirement they were asked to follow. Legal experts note that the effects of this policy extend beyond the actual number of cases that might reach a courtroom. Even the possibility of expanded denaturalization creates what many describe as a chilling effect across immigrant communities. Naturalized citizens who once traveled freely to visit family abroad are beginning to hesitate, wondering whether leaving the country might prompt additional scrutiny upon return. Others are becoming reluctant to interact with government agencies at all, even for routine matters such as renewing documents, applying for benefits, or correcting records. Simple, everyday actions that used to feel normal can suddenly feel uncertain. Updating an address, reporting a change in circumstances, or filing official paperwork may now be viewed as inviting attention. Over time, this kind of uncertainty can gradually affect trust in the institutions that citizenship is supposed to connect people to. Instead of feeling secure in their status, naturalized Americans may begin to feel perpetually uncertain. There is also a broader concern about fairness and equal treatment. If immigration offices are expected to meet numerical targets for denaturalization referrals, will certain communities face more scrutiny than others? Will people from particular countries or backgrounds be reviewed more intensively simply because of where they were born? Advocates note that even if the policy is intended to be neutral, the possibility of unequal application exists. The possibility that naturalized citizens could be treated differently based on nationality or ethnicity raises important questions about equal treatment under the law. At its core, this discussion is not merely about documentation or legal procedures. It is about the fundamental meaning of American citizenship itself and whether that meaning is now being reconsidered. At a deeper level, this entire issue prompts the country to address a question that has rarely been asked so directly. What does American citizenship truly mean? For generations, the promise was clear. Once you became a citizen, you were American in every sense, with the same rights, protections, and permanence as anyone born in the United States. Naturalization was intended to eliminate the distinction between immigrant and citizen permanently. But if citizenship can be revisited years or even decades later based on old documentation or shifting enforcement priorities, that promise begins to feel less certain. Some argue this creates the possibility of a two-tier system, one for natural-born citizens whose status cannot be questioned, and another for naturalized citizens who may always face the possibility of review. That concept challenges what has long made the United States distinctive. The belief that anyone, regardless of birthplace, can become fully and permanently American. Supporters of stronger enforcement maintain that protecting the integrity of citizenship requires firm measures and that genuine fraud must have consequences. But others counter that citizenship should not feel temporary for people who followed the rules in good faith. As this discussion continues, it is becoming clear that the conversation extends beyond individual cases. It concerns trust, belonging, and the long-term relationship between immigrant communities and the nation they chose as home. For the 26 million naturalized citizens living in the United States today, the environment is shifting. The assumption of absolute permanence no longer feels as solid as it once did, and that change alone represents a notable development in American immigration history. In times like this, practical preparation becomes more valuable than worry. Immigration attorneys and legal experts are encouraging naturalized citizens to take straightforward but meaningful steps to protect themselves and reduce uncertainty. One of the most important recommendations is to review old immigration records carefully. Maintaining copies of every application form and supporting document can make a significant difference if questions ever arise. Ensuring that information across different filings is consistent or at least explainable can help prevent misunderstandings. Experts also advise naturalized citizens to be thoughtful before international travel, especially if there were any complex issues in their immigration history. Consulting a qualified immigration attorney before making significant filings or traveling abroad can provide peace of mind and professional guidance. None of this suggests that most people face immediate concern. The vast majority of naturalized Americans have nothing to be concerned about because they obtained their citizenship honestly and legally. But in a changing policy environment, being organized and informed is always preferable to being unprepared. Staying aware of new developments, understanding your rights, and keeping accurate records are practical ways to navigate this new environment without unnecessary concern. Above all, it is important to remember that citizenship still carries strong legal protections, and denaturalization remains a complex and difficult process for the government to pursue. Awareness and preparation, not worry, are the appropriate responses to uncertainty. This information is provided for educational purposes only. Individual situations vary, and anyone with specific concerns should consult with a qualified immigration attorney for personalized guidance. If you appreciate clear, fact-based explanations like this and want to stay updated on how immigration policies are developing, consider subscribing to this channel so you never miss important information that could affect you or your family. As we approach 2026, this topic is likely to remain in the news and new details will continue to emerge. The discussion around denaturalization is still developing, and many legal developments and policy discussions are expected in the months ahead. What matters most right now is staying informed, asking the right questions, and understanding verified facts rather than speculation. That is all we have for this bulletin. U.S. Immigration Info Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you have not already, please subscribe to U.S. Immigration Info Channel. Thank you for watching, and we will see you in the next video.